And during the course of your practice here in the Atlanta area, tell us a little bit about your involvement. And I'm just going to refer to these as the election interference cases. I think there's 16 or 17 defendants. You are involved in those cases, I know from seeing the news.
Yes.
Who do you represent?
I represent a gentleman named Michael Roman. I was hired late August, early September, around, I think it was late August, to represent him. He lives out of state, does not live in Georgia. Yeah. But so I've been his defense attorney since the time of indictment.
All right, so late August or September of 2023?
Yes, I began working on his case in late August of 23. I think I looked this morning, I filed my official entry on September 1st of 23, and then I negotiated bond for him, walked through the turn-in process, and began negotiations with the prosecutors.
What exactly is he charged with? What's the offense he's been charged with?
He's charged with conspiring to violate the Racketeering Act, so RICO. He's also charged with some of the more specific allegations for him are attempted and conspiracy to file false documents. So essentially, I've classified the indictment. The easiest way for me to classify the indictment is there's the folks that are federal officers, there's the folks that are charged in the alternate elector process, and then there's Coffee County. He's in that middle section.
So that's the alternate elector process?
Yes.
And those are the documents that are deemed to be false. They're
Yes, that's what he's charged with. He's charged with false, filing false documents, false swearing, things like that, forgery.
And to be clear, you do not represent any of these alternate electors.
No, I only represent Michael Roman.
And you don't represent Donald Trump?
No, I do not represent Donald Trump.
So your involvement in the case is just for Michael Roman?
Yes, exclusively Michael Roman, and that's my duty.
You have produced quite a few documents to us.
Yes.
Do you have any concerns as to whether any of those documents are protected by attorney-client privilege?
I don't have any concerns about that. I do have some privacy concerns because you mentioned earlier that there was some financial documents that are not redacted, and so those would need to be redacted. That would be the only thing, but they're not. Phone numbers, I believe I redacted all the phone numbers, but there are some financial documents that are probably sensitive.
Okay. As far as Mr. Roman is concerned, is he given you permission to speak freely about his case and about the evidence or documents you've accumulated in the course of his defense? Yes,
we went over the subpoena that I received and the classification of documents that I was asked to give. All of those were things that I obtained through discovery, not discovery from the state, but through my own. So we have a protective order in the case. So anything that I've obtained through the state could potentially be subject to that protective order. But these were all documents that I obtained through my investigation.
Okay. Most of the members of this committee are attorneys, but not all.
Okay.
And I recognize that the general public will be hearing some of this or either now or later. Tell me a little bit about when you're talking about state's discovery. What do you mean by that? I know, but everybody else may not.
Yeah, definitely. Yeah. So we have a statute in Georgia that allows us to do what's called opt-in. So if we opt into the discovery statute, that means we're engaging in reciprocal discovery, which means that the state has to give us a copy of all of the material that they plan on using at trial. They also have to give us copies of anything that would be arguably exculpatory. And so in this case, there's been a lot of discovery exchanged because obviously there's a lot of defendants. And if they wanted to classify something as sensitive, they would do so. And then if we wanted to be able to disseminate it to any third party outside of our practice, we would have to have court permission to do that. Yeah. But when we are investigating a case, not everything comes through discovery. So in general, I would investigate a case on my own, and those items are things that I did not receive from the state. So we've got different classes of documents. The documents that I actually received from the state through discovery, through formal discovery, and then documents that I developed on my own.
Okay. And out of these documents that you've obtained from the state through formal discovery, that they're obligated to provide defense attorneys to fairly defend your client, some of those have been deemed to be sensitive and that are not freely disseminated?
Yes, yes. The state, how the protective order works, and the protective order is public. It was publicly filed. If the state deems something sensitive, they let us know that, and if we dispute that or we have some reason that we want it to be able to be disseminated, we would have to go to the court and basically argue over that.
Fair to say any of the documents you have provided to our committee were things that you obtained outside of that formal discovery process and are not subject to any protective order?
Yes, I did not. Nothing that was subject to the subpoena or that I provided was something that I got from the state, and nothing was subject to that protective order. I went through and was very clear on that.
Okay. And I'm wanting to make sure of this because this committee has made it clear from the beginning it is not our intent in any way to interfere with the criminal prosecutions, and so I would not want to be circumventing a court order that was for the protection of the privacy of the parties to that case. It is not our job to interfere in that case at all or in your motion to disqualify Ms. Willis.
I appreciate that, and I was very cautious because I certainly don't want to go against a court order
Sure.
Protecting, so I did not disclose any of those documents.
So tell me a little bit about the special grand jury process. It sounds like that occurred before you were ever even hired in this case.
It did. It occurred, and my client, Mr. Roman, was not involved in that at all. So he was never someone that was issued a target letter or a subpoena or contacted. So he was never involved in that either. So he didn't have counsel, obviously, since he was never involved in the special purpose grand jury. But in my role defending him now, I've obviously reviewed all of the things that happened with the special purpose grand jury that I have access to. So it's my understanding Ms. Willis obtained an order from, at the time it was Chief Judge, I believe it was Judge Brasher, who was the Chief Judge at the time, obtained an order to impanel a special purpose grand jury, and I followed that in the news before I was involved in the case because it's very unique. It's not something that happens very often. Normally when we see a special purpose grand jury, it's some type of investigation into a jail or something like that. So it was kind of unique to see that. But from reading everything, my understanding is a lot of the witnesses weren't willing to necessarily talk without a grand jury, and so that's one of the reasons that they had to impanel a special purpose grand jury. But it was very unique.
I've been practicing here a long, long time, and I haven't seen a special purpose grand jury to basically advise the DA, apparently, or a subsequent grand jury as to whether there's evidence to prosecute. Is that essentially what it did?
That is exactly what it did, yes. So, and now through the discovery process, I've been able to review a lot of the transcripts and also talk with a lot of the lawyers who were involved and witnesses that were involved in the special purpose grand jury. But that's what they did. They used that process to subpoena, particularly out-of-state witnesses. So in Georgia, it's always difficult when we have a witness who's out of state because we have the interstate compact. We have to get a certification to get a witness subpoenaed from out of state. It is not easy. It is one of the more difficult aspects of our job. So they used the grand jury process, a special purpose grand jury process, to bring in testimony and bring in witnesses from out of state. They issued a lot of target letters to people back and forth. That there was a lot of people that were targets and then weren't targets who testified, maybe negotiated some type of immunity, things like that throughout that special purpose grand jury.
Okay. And is that made public to other defense attorneys if immunity has been granted to any witnesses?
I don't know if it was made public originally. I know that some of it has been provided to us through discovery. We had a motions hearing where the judge ordered that the state give us copies of transcripts because they had everything recorded. So there's a transcript from the special purpose grand jury. It's my understanding there's a transcript from just about everything, but it does appear like sometimes that was cut off. So there are some sections that were recorded and then maybe a section wasn't recorded and then they went back on the record. But it was recorded, which we rarely get in a regular grand jury. We rarely, if ever, get that type of testimony. So that was very unique to have.
Is the state required to let you know if they've granted immunity to any witnesses that may have been utilized in the special grand jury process or in seeking the indictment?
Yes, they are. And some of that has been given to us through discovery. Some of it has been given to us from other attorneys, the attorneys who maybe represented those parties. There was a lot of back and forth. There were a lot of, and this, I believe this was all public, that some of our state representatives, I think the governor in particular, were subpoenaed, and there was back and forth over who could grant immunity, who had the power in that office to grant immunity, and that's something that I reviewed in my work on this motion with the DA's office because Mr. Wade was the one that took over that power. And so the emails that were attached to a lot of the pleadings, it was interesting. It first started out that there was someone else in the DA's office who's actually an employee of the DA's office who was negotiating all of that. And then it evolved to another member of the DA's staff, and then ultimately it was Mr. Wade, and there's emails where he said, I'm it. I'm the only one that can grant immunity. I'm the only one that has the power to do this. I'm in charge.
Was he engaged or involved in the special grand jury process?
Oh, very much so. He was by far the lead of it.
And do you have the timeline of when that special grand jury was authorized and when it began to meet?
Yes, I don't know the dates off the top of my head, but there is an order, and I can review it. I brought some of the pleadings with me, but it was authorized sometime. So he was appointed. The timeline. He was appointed in November 2021 to work on this case. It was sometime after that Ms. Willis sought the special purpose grand jury and got authority to do that, and then that went through several months, and then they issued a report to her.
So he was hired by the Fulton County DA's office before the special grand jury was authorized or
Yes.
impaneled? Okay. And so he was involved from the very beginning of that process?
Yes, and he was actually hired, I believe, before it was even, I know it was before it was impaneled. I believe it was before the order was even issued, though.
And do you know what his role was as what's the official term? A special assistant district attorney?
It's a good question. I'm not sure. He usually goes by special counsel or special prosecutor. I don't believe he goes by special assistant district attorney. I don't think he's permitted to do that. I've studied these statutes a lot, and there's no real term for it. I've heard him go by independent counsel, things like that, but I don't really think independent counsel would be an appropriate term because he's not independent. So I've studied, I did not know this before, but I've studied the structure of the independent counsel in the federal system. They're actually a separate office. They have their own appropriations to have a separate office, and they are kept separate from the U.S. Attorney's Office. So that would be where you get the independent counsel term from, or independent prosecutor. He goes by special usually, so special prosecutor or special counsel, and I think that's because he's not independent.
Is this commonly used in the state of Georgia? I don't know the scope of your practice. I'm not familiar with DAs doing this often.
No, and so I do practice throughout the state, and I've practiced in almost every county in the state at some point in my career, and it is very rare. I've had instances where there is special counsel, but those are very limited, and I can tell you about those, and then I can also tell you what I did to investigate that, because I had the same question. So first—
Just so you'll know why we're asking, the scope of this committee is we've heard a lot of the allegations, and you, as a matter of fact, made most of them, or made
Right.
some of these public, and there's of course a public, outrage or uproar or concerns about some of the alleged improprieties that you have brought forth, both within the in the system, kind of what's appropriate conduct.
Right.
And also financial improprieties. And we're tasked with investigating and finding the true facts, and not just taking the press at face value. And that's why we're asking you for documents, et cetera, so we can independently verify the various allegations that have been made. But we're also specifically tasked with, if necessary, amending existing statutes.
Right.
Or creating new statutes to build guardrails or whatever to essentially restore the public faith in our criminal justice system, in its impartiality and its fairness. And I have looked at some of the existing statutes, but it's very sketchy. What is the real authority? And we wonder if we need statutory authority or statutory limitations. And so I want to explore with you a little bit what the authority is for a special grand jury to be conducting a criminal investigation, and also the use of a special assistant district attorney is what I'm referring it to.
Right.
But and so that's the context. You have done that research, so help walk us through this just a little bit. Is there a statutory process that gives authority to utilize a special grand jury to advise a DA, or to essentially accumulate evidence for a DA to determine whether or not to indict?
Right. So the first So the first question was about whether this happens throughout the state or not. I did do open records to every single district attorney in the entire state of Georgia to find out, because I wanted to know, I knew based on my practice that it was a very rare process, but I wanted to know, I wanted the data. I wanted to actually see it. So we did an open records for every single district attorney. We have received responses from almost all of them. There's only a couple that we haven't, but I don't know that those would be big factors. The few that were remaining, I think it was Augusta that I haven't received one from. But I talked with two of the prosecutors in those districts. There's only two that actually use something that would be akin to this. And one of them said they haven't done it in years, but they have done it. And they paid between $40 and $40 an hour, which tends to be about the going rate for appointed counsel. It's between $40 and $60 an hour, I know, for appointed counsel in most counties. And then the other county that did use them, they use a part-time solicitor. And that DA said every time that they would have maybe some overflow work, an appeal or something that they had extra work to do, they would hire this part-time solicitor. So it was someone who was already a government employee, and they would pay $45 an hour for this person to do work. So those are the only people. This is a very unique to Fulton County, which I assumed, but I didn't know until I did the research. Nobody does this but Fulton County. And the AG's office does it, and so we got a lot of arguments from the state about, well, the Attorney General's office does it, but that's a whole different statute. It's not even the same section. So the Attorney General is authorized because they represent all of the state agencies. They are authorized to hire outside counsel, and they have to because there's a lot of conflict issues, and so it makes sense. So you've got different needs for hiring outside counsel. You've got conflicts, if there's a conflict, and if there's a conflict, you'd have to hire someone who's outside of the office. You couldn't hire someone like in this case, like Mr. Wade, to be special counsel because they're in the office. So you can't, when you have a legal conflict, you have to have, the offices have to be separate. So with the AG, that's usually what happens. Sometimes it's specialized knowledge. I mean, you've got people who are representing commissioners, you've got people who are representing, people in certain agencies in the state, in certain types of power. And so it might be a specialized practice area. So the Attorney General is authorized, and they actually publish it on their website, all of the rates. It's very transparent. So I went through and looked at everybody's rate. I mean, it's very transparent. How much they pay, it's based on experience. They get approval for that. They get approval for the appropriations for it. And it's just extremely transparent, which is in direct contradiction to how it works in Fulton County.
And do you know how many judicial districts we have in Georgia? I don't.
I do not. I could look at my open records request. So the judicial districts, there would be a district attorney for each of those. And so those are who I sent all of this.
It's over 50.
It's over 50. I think it's 59, but I'm not positive.
That's what I think.
I think it's 59.
So out of those 59, you reached out to all of them to see if their district attorney's offices for each judicial circuit ever utilized a special assistant, outside counsel.
Yes.
Okay. And out of those, only 3 of them have ever done it?
Only 2.
Only 2.
Only 2 had ever done
Fulton County is one of them.
Only 2. Yes. I'm sorry. It's 3 counting Fulton County. Okay. I did not send an open records to Fulton County on that because I already knew that they did it.
Is there a statute that authorizes that?
There is a statute, and I cite it, if I may, I cite it in my brief.
Feel free.
Okay, thank you. I don't want to misquote it. Let's see. So it's 15-80-20. And how I came to learn that is I actually contacted the Prosecuting Attorney's Council early on in this case, and because I was trying to figure out the legality of this. I did open records, and I found out how much money the special counsels in this case were being paid. And there's about 20 different people in Fulton County that are paid under this type of arrangement. It's the largest personnel budget item in the DA's office.
Why wouldn't you just hire more assistant DAs and have them in-house?
That's what I didn't understand, and that's what, I mean, in my opinion, obviously, I think that's what should happen. But the reason that it wouldn't happen is because if you're hired as an assistant DA, you can't take private work. So the statutes, and they're all in section 1518, 15-18. The one that gives the authority for this is 20. But all of those, if you read all of them, it makes it very clear that if you're going to hire more assistant DAs, they have to be paid the statutory rate. So you can't just pay an assistant DA anything you want. You could not pay them $300,000, something
What
like that.
is that statutory
It's,
rate?
I don't know it off the top of my head, but it is in the statute. I know that, like, District Attorney Willis, for example, I think it's around $200,000, and that's one of the top paid people. So most of the people are paid, somewhere between $100,000 and $150,000, something like that, depending on their role, depending on county supplements. So what the statute says is it gives a state salary, and then you can get a county supplement. But all of that is around that range. I'd say around $150,000. But there's limitations. So to answer your question, why you wouldn't just hire an assistant district attorney, first, they couldn't make as much money as independent counsels, or I'm sorry, not independent, special counsels, couldn't make that much money, but they also would be limited in their law practice. They wouldn't be able to have private practice, and that's by statute. So if you are hired as an assistant DA, you cannot have a private law practice also.
Do you know how many there are in Fulton County DA's office?
How many special
many-
prosecutors?
No, how many assistant district attorneys?
No, I actually open records that, and it was declined. So we actually have a pending open records lawsuit, which I did bring. I asked for that. I asked for how many were hired, when they were hired, when they were fired, and they declined to give me that under the Open Records Act. So we ended up filing a lawsuit, and that's still pending.
Because it just occurs to me, I think there's certainly dozens of them.
Yes.
Maybe 100.
I think 100 would be a fair example, or a fair number based on just my knowledge of it. But there's quite a few, and if you had a certain amount of money that they spend several $1 million on these special prosecutors, that could be spent on a lot more assistant district attorneys.
Do you know the process in Fulton County on how you approve the budget for the DA's office? Is that something controlled by the county, or does the DA have total discretion?
It's controlled by the county, and I do know I actually went back and watched a lot of budget meetings. They have their budget meetings online. I read a lot of the transcripts, and so it's very interesting. It's kind of a long answer, though. Depending on who you are in Fulton County depends on how your budget is approved. So, for example, the county attorney, if they want to hire special counsel, okay, and pay them hourly, like in this case, they go and they get that approved at the county level. They actually appear in front of the county Board of Commissioners and say, we need to hire this person at this rate, and they approve the rate. They monitor the bills, they do all of that stuff. So that's what happens at the county attorney's office.
Okay, the county attorney represents the county, is not prosecuting criminals like the DA does.
Correct, it's civil. So the county attorney does all civil things. In this case, they actually did end up representing the DA in some of the open records issues, which is a whole other issue. So the county attorney, the civil body, they actually go and get county approval from the Board of Commissioners. And there's actually a resolution. So I think I attached as an example in one of my briefs, a copy of a resolution just to give as an example. I'm pretty sure I did. And it's very transparent. They get it approved. Yeah, here it is. It's called a resolution, and it's a resolution authorizing funding for additional personnel. And basically, they go and they say, we need this for this project. We need this budgetary item, and it's approved. It comes out of their budget, though. So they're not going and asking for more money for the county attorney's budget. They're just asking to use the county money that they've already been allotted for this special counsel. The district attorney has taken a different position, and I was surprised, so I watched hundreds of hours of Board of County Commissioners meetings just to make sure that I wasn't missing anything, that she never went and asked for approval for any of these special prosecutors.
Her budget is granted through the Fulton County?
It is.
It's in a part of its budget?
It is. These special prosecutors have been paid a couple different ways. They were paid with state seizure money. So the first, around $100,000 of Mr. Wade's funding came from state seizure money. It appeared from looking at the budgets for the state seizure that fund ran out. So then it started coming from the general fund. But it was money so Ms. Willis had a budget right around the time that she hired Mr. Wade and these other special prosecutors. She went and asked for more money for a backlog, and so she was given extra money, and that money's been renewed since. It was given to her to hire 55 additional personnel, and it's actually in the resolution. She went in front of the Board of County Commissioners and asked for it.
When was that? Do you know?
That
Do you
was,
have
I
handy?
do actually, because I attached it to my brief, so I know the dates of things. September 15th, 2021 is when she presented her PowerPoint to the Fulton County Board of County Commissioners. And she gave a lot of statistics about all the unindicted homicides. It was mainly about homicides. It is, you know, there was some about sexual offenses, but it was almost all about homicides. She said that, you know, why am I here? The great trifecta: crime is on the rise, historic mismanagement, and then the COVID backlog. And so she asked for quite a bit of money to hire additional personnel. It was, I can tell you, that year it was $780,000.
And that's in the fall of 2021, just before this special grand jury was impaneled?
Yes. So that happened, she was awarded that money September 15th, 2021, and she actually did get the resolution and the process that you would normally expect.
How much was that addition or increase to her budget?
Not to exceed $5 million.
Wow.
So she was awarded for the end of 2021, which this is September 15th. She was awarded for September until December 31st, $780,000. It said, and then the next year, not to exceed up to $5 million.
All right, so hang on for 1 minute. My vice chairman here, Chairman Dolezal, is way more high-tech oriented than I am. And
Okay.
he has downloaded some of your documents that you produced to us that I had asked him to have available so we could see them here. And I think you have produced to us this PowerPoint presentation that Ms. Willis made to the County Commission in September of '21 to allegedly fund backlog of murder cases, et cetera.
Yes,
right?
that would be Exhibit A to that motion. Yes,
Okay.
that's it.
And is that what we have on the screen here? Let's see if we can flip this one right.
It is.
Okay. So this is part of her PowerPoint presentation for additional funding over and above her previously appropriated budget from the county?
Yes. Yes, it is.
Okay. All right. So what were the county procedures for approval of funding for, you know, additional outside counsel, or in this case, it sounded like she was going to hire 55 people in-house to help
Right.
with the backlog. Does the county have guidelines or rules or regulations as to how you get funding approved for either additional staff to work on her backlog of homicides or for special counsel to assist you?
Oh, yeah. Yes.
What are those proper procedures?
You have to get approval by the Board of County Commissioners. And the statute, so the statute that I cited originally, 1820, that statute actually is the one that it says that you can hire additional personnel like this, but it has to have county approval.
Okay.
So, I mean, the statute says it already. You know, when you were asking about changing statutes, I mean, it's clear in the statute that it has to be approved by either local law or the governing authority, which would be the county in this place, and in this instance. And it's very specific that it can't be paid with state funds.
Anything in that September 15th of 2021 proposal or request for funding that addressed or contemplated special counsel to pursue indictments against folks for election fraud?
No, not at all. And I watched the video. It's online. Her speech, where she used the PowerPoint in the speech. There's nothing about that at all. And in fact, what was submitted was pretty specific. It was to hire 55 new employees, not contractors, employees, in November 2021 and December 2021. And I did open records based on this, asking who was hired and the dates of hire, because I wanted to be able to track that, and that was denied.
And who made that denial, the DA's office or the county?
The DA's office. And I did bring the open records lawsuit, just in case you had any questions about that. So it was the county, and I can tell you when I filed it. Let me see. And we went back and forth, and you know, I requested it several times, but it was Dexter Bond at the DA's office who sent a letter back and said, we don't have that. We don't have to give it to you.
He's like the chief assistant for Fonnie Willis.
He is, and he's also the one who who went to the Board of County Commissioners whenever they needed funding. So, you know, if they had some large printing, and they had a big rebranding campaign where they had a lot of money that was spent on this rebranding, like posters and things like that around the office, and he had to go and testify in front of the Board of County Commissioners to get that paid because they were not paying it. So he's sort of the go-between with the Board of County Commissioners. His official title is something like Chief Legal Officer or something like that. But he's an attorney.
So you've gone back and reviewed all of the Fulton County Commission's minutes and records to see what requests were made and if there was a resolution granting the additional funding?
Yes. Oh, yes.
Was there ever a request for additional funding for a special prosecutor to pursue these election cases?
No, there wasn't, and I knew that before we got the district attorney's response, but subsequently we got a response from the district attorney's office that said, we didn't do it, we don't have to do it, I'm a constitutional officer. So their argument was, we don't have to comply with those statutes or those rules because she's saying she's a constitutional officer, so she doesn't have to get county approval. She can spend her budget however she wants.
Then why would she have gotten county approval for the other 55 attorneys?
So what I've surmised is that was because those were staff members, and so she went and asked for additional budgetary money. She needed a higher budget. So for those 55 people, she went and asked for more money because she didn't have enough money. And once she was awarded that, it's her position now that she can spend that money however she wants.
Doesn't have to use it for 55 new staff. She can use it for Special Attorney General.
Yes.
Not Attorney General,
Special
DA.
counsel.
Okay,
Right,
counsel.
yes, essentially. That is their argument in their reply briefs that they filed in court, that they have inherent authority. They don't have to comply with the county ordinances, don't have to comply with the statute.
So they don't have to comply with our state statute?
That they have, once they're awarded the budget, they can use that budget however. I mean, how their motion, and I'm happy to send the motion, it's public record, but how their motion argued it was, if they get $5 million, they can pay that to one person if they want, as long as because the voters authorized her to do that. So the county, their position is the county authorizes a budget, and she can pretty much has inherent authority to do it however.
Even though she specifically asked for the money to prosecute backlogged homicide cases in Atlanta?
Yes.
Okay. What's your opinion on that? You think the statute or county procedures permit that?
No, I do not. And I cited several different county ordinances. So when I read the statute, when I read 15-1820, and it makes sense, it makes sense intuitively. As lawyers, when we bill, someone is reviewing our bills. I mean, that's just, that's the process. If you're in private practice, your client authorizes your bills. If you're doing public defense, which I've done public defense, I've done appointed work, the governing agency approves my bills, and they will cut them. They will regularly cut them if they're too high. And so there's always some type of budgetary authority that's reviewing everything. So I thought it was very strange that in this case there isn't one, and that there's really no oversight because it is public money. So I know that it's an elected official, but it's still public money. And I don't live in Fulton County, so it would probably aggravate me more if I did.
So we have the code section up that you're referencing for prosecuting attorneys getting additional personnel. That's what Mr. Wade would qualify as, correct?
Yes. So under B, that's the section that authorizes the appointment of special counsel. And it says the manner and amount of compensation to be paid is fixed by either local act or by the district attorney with the approval of the county. And so that's where that's our argument that this was not appropriate expenditure because it did not have county approval.
So our state law requires if a DA is going to go seek outside counsel, I'm going to call them, that must be approved by the county commission.
Yes, without a doubt.
And there are only 3 circuits that have even utilized this procedure.
Yes.
Do you have any idea what rates of pay were approved in those other judicial districts, or whether they went through some type of approval?
So one was $40 and one was $45, and the annual amount that they spent did not exceed $2,000.
And what did Mr. Wade receive?
He's received about $700,000 so far.
And what's he paid per hour?
$250 an hour.
Has Fulton County been given any opportunity to approve or reject those bills, or the fact that he's even hired?
No, and that's an interesting point. So one of the things that the district attorney argued in their motions was that they don't have to have the actual bills approved. So she is the one that approves the bills. So essentially what happens was he would submit an invoice and she would sign off on it and send it to purchasing, and then purchasing would pay for it. So their argument in their motion was that the oversight is by purchasing saying a pay, that she would be the one that reviewed the time. So Ms. Willis reviews the time, and then it gets submitted to purchasing, and purchasing then pays it. And so that's the oversight, in her opinion. In the state's opinion, the oversight is from purchasing, but purchasing just gets a bill and pays it. They don't actually look at it and see if the work's done.
Does Ms. Willis do that? Is she required to approve these bills submitted by the special counsel?
So the contracts indicate that the bills are submitted to her. She doesn't sign off on all of them. A lot of them were signed off on by other people in her office, purchasing people and things like that. So there's no evidence that I was able to find that she actually scrutinized these bills or reviewed them or anything like that, but she may have.
Okay. And you mentioned that attorneys that are working for state agencies or whatever, including the special assistant attorney generals, submit bills on like itemized statement on what services they've rendered?
Yes, and the Attorney General has very specific guidelines on that, what you can bill for, how you have to bill, and is told to remind. There's a reminder that this is public service, so essentially be judicious in your billing.
Right, you go voluntarily get underpaid to be able to
right.
help the public.
And a lot of people view it as public service, I think.
Are those bills submitted in like tenths of? I do some billing, in my job, and it's usually tenth of an hour.
Yes.
Are there rules or guidelines or sort of standards of practice and how you bill?
Yes. So most law firms, I know because my husband used to work at a law firm, is 6-minute increments, and that's how most lawyers bill in the private sector. Public, it appears that most of them are in 10-minute increments. I know that that's what all of the indigent defense groups, they all are 10-minute increments, but I've never seen anything above that.
Okay. And on the open records request you made to the other judicial circuits, how did those outside counsel bill?
Honestly, I would have to go back and look. They were very small bills, though. They were making less than $2,000 a year, so they were small bills, and they were project based, which I think is also different. They would be hired to do a certain project.
Okay. If Ms. Willis had hired a employee, one of these 55 employees, and tasked them with the job of going through a special grand jury process and helping seek indictments, investigate these allegations, what's the most they could have made?
Well, first, she couldn't have hired Mr. Wade because it violates county policy. So she would not have been able to hire Mr. Wade as an employee.
How does that violate county policy?
They have a lot of policies on nepotism, relationships, personal. There's a lot of guidelines in the county policies. So she would not have been able to hire him. It would not have been approved. And that would be something that actually did have to get approved by the county. And because of their relationship, that wouldn't happen.
So she wouldn't have been allowed to hire him because of violations of other county policies?
Yes.
He couldn't have been a direct employee of the district attorney's office?
Exactly. He could not.
This process circumvented those rules and ethical obligations?
Yes, it did.
Okay. Let's say it wasn't Mr. Wade.
So if it wasn't Mr. Wade and someone else, I believe most of the other prosecutors on this case make around $175,000 annually.
I interrupted you. I'm sorry.
That's okay. No, that was the answer. So if she had hired Mr. Wade or somebody else as a salaried employee, they would make around $175,000, most likely.
So using this technique that didn't obtain approval and didn't have to follow the ethical guidelines of her own office, she was able to pay him $700,000 over 2 or 3 years.
Yes, and
way more than he would have made as an employee.
Way more, and also he's able to have a private practice, which is significant because you're not able to have a private practice if you're an employee. So that's a big issue.
Have you reviewed his billings?
Yes, I have.
Okay. Senator Dolezal, will you give us an example of one? I think we have one we're just going to pull up randomly, kind of. Okay. Is that an example of the type of invoices he would submit?
Yes, it is. And so
that's an actual one, isn't it?
That is an actual one. And so there's a couple things on this. You asked earlier about the authorization, that stamp that says okay to pay. I believe that's Dexter Bond's signature. So that was one where Ms. Willis didn't approve it or didn't review it at least as far as we know from the signatures.
But her chief legal officer did.
Right. So they would do that stamp okay to pay, sign it, and then send it to purchasing. But yes, this is one of the bills. And so he had monthly caps, which went up. There were a couple different contracts that were renewed. So we had one contract that expired, another contract, and the monthly cap was $35,000 a month. So that's where you see the total. But this billing is not something that you would normally see.
All right, well, I'm noticing it lists the day and just a number of hours. There's no real itemization of exactly how much time you spend doing whatever type of task.
Right. There's none at all. And I also open records because in Fulton County you have a badge to access everywhere. So I didn't open records for his badge access. I was told he didn't have a badge. I was told by other witnesses that he did. So, I don't know. But that you would, if you were doing these things in the office, you would. I used to be a Fulton County employee. You have to scan, and they keep track of all of that. So you have to scan your badge to get in to certain places. So if he's doing this, even as a contractor, contractors at the jail have badges. The medical providers have badges. They all have the badges that they scan. I open records to the sheriff and the DA's office, and both of them told me that he did not have a card, an access card. But in order to do this, I would assume he would have to have one to get into the DA's office, and I have been told that he had one, and those you'd be able to see when he went in and out. Okay. But I was denied that.
Anything unusual or irregular about, this is just an example, Bill, about the way he billed the county?
Completely. I mean, you would never see this. This is what I would call block billing. So one of them, for example, it's 28 hours over the course of 2 or 3 days. Team investigation meeting and drafting. I went back and looked to try and see, a lot of these were like drafting. And at the time, I'm not sure what would have been drafted because most of this was during the special purpose grand jury. So there's not really a whole lot of drafting. And we've obviously never seen anything that he specifically has drafted. But I also calculated these team investigation meetings. So the majority of the billing are things like meeting with team. So if you see here, it's got team investigation meeting. Then it's got team meeting and argument prep. And then meeting with team. Most of his billing is meeting with team. Team meeting, team investigation, team brain drain. He called it different things like that. But I went through, and that's the majority of the bill.
And this wouldn't be standard from what you see at block bill in 8-hour increments instead of, you said, 6-minute increments, or
no.
More specifically, and does not really give a lot of identification of what's being done.
It gives pretty much zero, in my opinion, identification. I mean, this is not something that we would be able to submit to a client ever. I can't imagine. I mean, they would, if I billed them $2,000 for 8 hours of meeting with a team on one day, and just research without what I'm researching. I mean, you have to be detailed in your bills because that's accountability. I mean, that's the only way as lawyers we can be accountable. Our clients aren't sitting in our office while we're researching, so I have to say what I'm doing.
And somebody has to approve it.
Oh, yeah.
And it's ultimately Fonnie Willis that was approving these either personally or through her designated assistants.
Yes.
And there was a written contract with Mr. Wade and the Fulton County DA's office?
There was, yes.
All right, let's see if we can pull that up, Senator Dolezal. Am I right that I think I've reviewed your documents, that there were more than one contract?
Yes, there were.
Right. Is this the first one?
Yes, that's the first one.
All right, so that says it shall commence November 1st of 2021 and go through October 31st of 22.
Yes.
Okay, so that contract began before there was even authorization to have a special grand jury and later in November of 21?
Yes, it did.
Okay. Does it specify that that's what his role was going to be, or is there any way that's disclosed to the public what he was doing?
No, up at the top, I believe it says, let's see, it just says attorney consultant. This one, so if you look under whereas, the first whereas, it says to provide legal services regarding anti-corruption matters. The head of the anti-corruption unit is a lady named Sonia Allen, and she was the one that was originally in the emails that I talked about earlier negotiating immunity and things like that. So she's the head of that unit.
So the DA's office has their own special anti-corruption unit already in-house?
They do, and they have a director of that. Sonia Allen is the director, or chief assistant. You know, she heads that unit, and she was the one that was originally on the emails negotiating immunity and things like that. And then it switched over to, there was some issue, I believe it was with Governor Kemp, on him testifying when, all of that stuff, and Mr. Wade took over and said, I'm the only one with authority. And so Ms. Allen sort of stopped working on the case, and she hasn't really worked on the case since.
From your experience and your knowledge of Mr. Wade and Sonia Allen, does he have any special unique experience or expertise that would make him better at this anti-corruption work than the head of the anti-corruption department in the Fulton DA's office?
No, but I mean, other than, no, he would not, but Sonia Allen also hired Mr. Wade in Cobb County before this contract at, I think it's like $550 an hour or something, to investigate deaths in the Cobb County Jail. So Sonia Allen was the chief, so when Neil Warren was the sheriff in Cobb County, Sonia Allen was the chief deputy. And so she basically ran the sheriff's office. They had a couple different deaths, and there were some lawsuits over access to that. A lot of the local lawyers wanted access to what was going on with the jail deaths. And Ms. Allen hired Nathan Wade to do that work, to do an investigation. And so a lot of this came out because they were ultimately sued. So I reviewed, part of what I did in this case was I reviewed all of those documents as well. Mr. Wade had to testify because one of the news organizations sued them and said that essentially Ms. Allen hired Mr. Wade to try to get around open records, to say that it was an open investigation so that they didn't have to give the jail recordings to the families about how these inmates died. Mr. Wade was a witness and had to testify, and he had billed a lot of money, which I don't have the figure, but I've got the invoices, but he had billed quite a bit of money to Cobb County, but hadn't produced any documents, and so he had to testify, and his testimony was that everything was in his brain, that he didn't have any written documents from anything. But that's where...
That was some years before.
That was some years, I think it was in 2020 maybe?
So
it was right before
when
this.
did Ms. Allen get hired by the Fulton DA's office?
When Ms. Willis took office. So when Ms. Willis took office was the same time that Mr. Warren, who was Ms. Allen's boss, was no longer the sheriff in Cobb County. So a new sheriff was elected, Craig Owens, and so he was elected in Cobb County. He took over that office. Ms. Allen no longer had a job, and she was hired by Ms. Willis to head the anti-corruption unit.
Okay. So from your documents you've produced and your news stories that I've read, apparently there were other special counsel that were hired by Ms. Willis?
Yes.
And to work on these specific RICO cases or election fraud cases?
Yes, so there's several, and so that's kind of a longer answer because there's a couple different classifications. Mr. Wade was, at the time that he got this contract, he was law partners with a gentleman named Terrence Bradley and another gentleman named Chris Campbell. So it was a three lawyer firm. Both Mr. Wade and Mr. Campbell had contracts also. They actually had contracts before Mr. Wade. So they both got contracts the month that Ms. Willis took office. They got contracts to do what's called taint work, which is essentially if, for anti-corruption, because it's a lot of police brutality cases, if there's things that could be considered privilege. So let's say the police union had a lawyer doing an investigation, they subpoenaed those records, those are privileged. Somebody has to review those to see what the DA's office can actually see. So it's that wall, that privilege wall sort of. So both of Mr. Wade's law partners had contracts to do that privilege review, that taint review, conflict review.
So you're seeing if there's tainted evidence, something that should not be revealed might damage another case, or it might be privileged and not subject to disclosure?
Right, exactly. And one of the best examples I could give is, in the Tex MacGyver case, he was a lawyer. They seized a lot of his documents. A lot of them were attorney-client privilege related to other people. The DA's office was not able to just go through all of those, so they had to have a taint team, is what they call it. And so that taint team and I don't know which cases, but the taint team involved Mr. Bradley and Mr. Campbell, who are Mr. Wade's law partners.
Basically, they're reviewing documents to see whether they should be produced or privileged by attorney-client privilege or something else.
Exactly.
Yeah. Not exactly prosecuting criminal cases then.
No, they weren't prosecuting criminal cases. But Mr. Wade testified that they were law partners at the time, so that he would have shared a third of whatever contracts they got. So those contracts, he was getting paid essentially from the law firm as well.
All right. So on this case, these RICO cases that you're involved in, one of them, there are other special counsel in addition to Mr. Wade?
Yes. So there's two other, on this case particularly, there's a lady named Anna Cross and a gentleman named John Floyd. And John Floyd has worked with the DA's office for many years. I actually was involved in another RICO case year before this one, which luckily my client resolved his case, so I'm no longer involved in. But that case, John Floyd had also helped craft the indictment. And, you know, he's sort of known as a go-to person for racketeering cases, so the district attorney would regularly call on him to help in drafting indictment. Anytime we would file what's called a demur, which is a motion to quash an indictment, he would usually be the one that came and argued it. And then Anna Cross was also hired, and she really focused on the work in federal court. And both of those sort of make sense to me because Fulton County prosecutors they're not necessarily barred in federal court. It's not something that would be required for your job. When I was a public defender in Fulton County, I wasn't barred in federal court. You know, I had no need to. I wouldn't have paid the dues, wouldn't have done that. So, you know, it's not something that would be required for their job, but Ms. Cross is experienced in that. So she was hired sort of as a subject matter expert to litigate some of the federal removal issues in this case.
Did those two individuals have contracts with the DA's office as well?
They have had contracts historically. They do not currently have contracts. It's very odd.
Did you review their billings?
I did. I reviewed their billings. Stark contrast. So Mr. Floyd, for example, he was only paid at a rate of $150 an hour. And Same case. And he
more experience and expertise in RICO cases.
I mean, everybody would agree. I think that John Floyd is one of the preeminent experts on RICO.
Yeah.
I believe he testified in front of the Georgia legislature when RICO was passed.
Did he have to submit itemized invoices?
He did, and his were very different. His were significantly reduced, and the big difference was he billed for the time that he was working on the case, not necessarily like 8 hours for team meetings and
He
things
have
like
itemized billings?
that. Very much so,
And
yes.
what increments did he bill in?
I might have some of his contracts with me, but it was either 10 or 15-minute increments.
Okay.
And so did Anna Cross. Now, Anna Cross was paid $250 an hour. Anna Cross is very well-known, very experienced appellate, federal lawyer, does a lot of complex litigation. She was a DA for many years, handled a lot of high-profile cases for the district attorney's office. I mean, I know her back from when, you know, we did death penalty work in Cobb County together 15 years ago. And then she went to DeKalb County and prosecuted a number of high-profile cases there, but just very well-known. And her bills were also submitted, but they were the same rate. They were $250 an hour, but they were much lower bills, not anywhere near the bills that Mr. Wade did.
Do you know how much Anna Cross has received during the course of this criminal prosecutions or
I'm not sure.
investigations?
I might. Let's see.
Okay. You said Mr. Wade had about $700,000 so far?
Yeah. Oh, Miss Cross was under $100,000, I believe.
All right. So if she's under $100,000, what about Mr. Floyd?
Mr. Floyd, much lower, even lower than Anna Cross. He has not billed in a while, so I've subpoenaed, or not subpoenaed, I did subpoena, but I also did open records for all of his bills. We've not been provided anything recently from him, so I'm not sure if he actually did bill, because his contract said you have to submit the bill within a certain amount of time. So I'm not really sure. They stopped responding to my open records requests, but when they did respond, they were very, very limited, very small bills.
Okay. And your open records request was to whom? The Fulton County government, the commission, or the DA's office?
I did them to all of them, and once especially that they stopped responding to them. So they have a portal, and if you go to the DA's office and you click open records, it takes you to the Fulton County portal. So if you try to submit it to the DA's office, it necessarily goes to a portal for the entire county. So you have to submit it through those. So that's where I would submit it. You can designate I think this is the DA, I think this is budget, things like that. So I would be over-inclusive just to make sure that I wasn't missing somebody. But every single time they would route it to the DA's office. So I would get a response that said it's been routed to the DA's office and, we're waiting on the response. There were one or two that I got from the county that didn't appear to be routed to the DA's office.
Right. And so who's refusing to produce these records to you?
The letter came from Dexter Bonds at the DA's office.
And
Dexter
that's
Bond.
why you filed a lawsuit against the DA's office to force them to comply with open records?
Yes.
Okay, that's still pending?
It is still pending.
Fulton County Superior Court?
It's Fulton County Superior Court. It's assigned to Judge Krause, I believe, and the county attorney contacted us and says they're going to be responding. So the county attorney is actually defending that lawsuit.
Right. And so they're telling you they're going to respond to the case or respond to the request now? You're waiting to see.
I believe the case. I haven't received any documents, so.
Fairly recent filing you filed there, or that lawsuit?
Yeah, so we filed it in January, and then they had a little shutdown in Fulton County where nothing was able to be file stamped. Our process server couldn't serve it until it was file stamped, and the Odyssey, the e-file system in Fulton County was hacked, and so it was shut down for a while. So it took us a little bit of time to get a file stamped copy back, but it's now been served. But it was filed on January 30th.
Of 2024.
2024. And I have a copy, which...
I don't have that. If you would provide us with that, then we'll give it to the Secretary of the Senate as a supplemental response to the subpoena.
I'm happy to. This is a clean copy.
Okay.
Yes, so you all can...
So what's the relevance to you? Why did you seek these billing records of these attorneys?
I wanted to compare the different billing, the different styles of billing. Also, there had been an allegation that I was singling out Mr. Wade, and so I thought it was relevant to see the rates that the other attorneys were paid, their billing, what type of billing, if they billed for everything. Just for example, when we're in court, one of the prosecutors may be arguing, Mr. Floyd and Ms. Cross aren't there billing, but Mr. Wade is always there. So that was one thing that I noticed, and I understand now that their response is that he sort of is like a case manager almost, so I guess that would be why he's always there, but I wanted to compare them and see.
Okay. I think I want to show a couple of things. Senator Dolezal, I want to show some of the other billing records, particularly ones that showed the trips to D.C. We hadn't had but a couple of days to review all your documents, and I skimmed these records because I wanted to know exactly what was going on. You'll see highlighted down here at the bottom on November 18th of 22. Interview with D.C. White House, 8 hours. Do you know what that references?
Based on another motion that was filed in our case and the arguments that were made by the DA's office, I believe that was when they met with the Department of Justice. They met with the January 6th committee. So one of the co-defendants filed a motion to try and get some documents, and the state had to respond. It was a motion to compel. I was there for it. I joined it, but I didn't litigate it. And the state said that they had to meet off campus, so because they didn't have a record of it, I guess you have to have a record if you go into the White House. And so they met with the January 6th committee off campus, and they said they had a really hard time getting that meeting, and they had to have someone who had some source or something to get them to agree to the meeting. But that's what, so the motion to compel was based on this entry, and this entry in response, they said they were meeting with the DOJ and someone with January 6th.
There's also an entry, May 23rd, 22, travel to Athens conference with, what is that, White House?
Yes, and we've tried to figure out what and who that was, because there was something happening at UGA Law School, and so we just assumed that it was someone that was there, and that's why they met there. But I don't know.
Do you have reason to suspect, or can you confirm whether or not Ms. Willis or Mr. Wade were coordinating with the Biden White House in the course of this investigation and prosecution?
I mean, the discovery, they've got, a lot of our discovery involves the January 6th. I mean, a lot of what we have in discovery is the same stuff that other places have. So they had to have gotten it from somewhere. And they also, they read a lot of the testimony. They played testimony in the special purpose grand jury. So, I don't know how they got all of that, but they got it somehow. And then, there's, one of the other things I did was I did a open records for the White House access, and we had records that Ms. Willis and the mayor of Atlanta were at meeting with the vice president.
Okay, and so this is the access history. How does that work? The White House keeps records of anybody that comes in and has any kind of official meeting, for sure?
Yes, and my understanding is it's highly regulated who can access the White House, and so you have to apply in person or apply ahead of time, and then they give you a time when you make the appointment, and they give you a time when you're allowed to be in and when you have to be out by, and they track you. And I mean, that makes sense. They don't want anybody lingering in the White House, but they keep that. And so they're called WAVE records, I believe is what they're called, and I'm not sure what that's an acronym for, but they're publicly available. They're open records.
And this record that's shown on the screen shows Fonnie Willis was a visitor with V. POTUS. I presume that's Vice President of the United States?
Yes, it was.
And what was the date of that back in, was that February sometime of 23?
February 28, 2023.
Is that before the indictment?
Yes.
Okay. Any further explanation of why Ms. Willis was meeting with the Vice President of the United States?
No. I know Dexter Bonds, and I believe that's the same one that Mr. I think it's Dixon, the mayor of Atlanta, was also there.
Okay. We're going to take a short break. We've been going at this for a while. Let's take a somewhere between 5 and 10 minute recess, and we'll be back. Thank you. We're in